Hi, today I'm talking to Howard Cohen from Winston Solicitors. He's been practicing for over 35 years. I wanted to talk to you about challenging a will. How easy is it to, or how would I go about challenging a will?
First of all, you need to have grounds to challenge the will. There can be various reasons for challenging a will. One could be if the will has not been validly executed, say if the witnesses didn't sign the will at the same time as the executor. Other grounds could include lack of capacity. When somebody makes a will, they've got to have sufficient mental capacity to make it. So if, say, for instance, they've got dementia, they may not have that capacity. Now, you do get situations where people claim that the person who made the will did not have capacity, and the burden is on them to prove that is the case. Where the will is professionally drawn, there's less chance of that happening successfully, because normally a solicitor, especially an experienced solicitor, will carry out an assessment on capacity before the will is drawn up and make sure that the person does have capacity, and their evidence would carry significant weight in a court of law. Of course, other reasons which are claimed, such as duress or undue influence. Now, these are very difficult grounds to rely on, because it's not just a case of somebody in the family, say, persuading the person who made the will to do it in a certain way. You've actually got to show that there's been coercion, pressure, so that they don't do it voluntarily. Another ground is to show that the person who made the will didn't fully know or approve of the contents of the will. Now, I'll mention to you there was a particular case which took place in court in 2006. There was an elderly Polish lady who in 1993 left her entire estate to various charities. And then several weeks before she died, in 2002, she changed her will. Now, this was a very frail and elderly lady who was terminally ill, and she left her estate to someone who had befriended her. So in this particular case, there were two arguments forward against approving the will. One was that the will was forged, and another argument was that of lack of knowledge and approval of the will. Now, there's a handwriting expert who showed that there's a real possibility that the will was forged. However, the view taken by the court was that it wasn't sufficiently proved on the balance of probability that the forgery had taken place. However, on the issue of lack of knowledge and approval, the court felt there was a suspicious situation here, because the person who wanted to prove the will and the friend had actually prepared the will herself. The court felt that was suspicious. There was a heavier burden on the person trying to prove the will, and they couldn't prove on the balance of probability that the testator knew and fully approved of the contents of the will. So the will was actually rejected. So that shows you that it's lack of knowledge and approval is a better ground to rely on than forgery, unless you've got very, very good evidence.
It's complex, but it sounds like you know your way around it. If someone is wanting to contest a will or wanting more advice, what's the best way to reach you?
Well, yes, the best way to contact me would be at winstonssolicitors.co.uk. Thank you.
Brilliant. I look forward to chatting to you again soon.